Okay, so welcome to the podcast entitled Co-Ownership, Rights and Obligations. In this recording, which will go for about 15 minutes, we're going to talk a bit about the rights and obligations that co-owners have to one another. In the previous podcast, we talked about the creation of a co-ownership. In this situation, we're going to say, okay, they've got a co-ownership on foot, whether it be joint tenants or tenants in common. But what happens when one of them does something that perhaps interferes with the rights of another person? And what common obligations do they have to look after the property, for example? So here's where we are in the broader scheme of things. We're looking at the rights and the obligations between those co-owners. Here are the general categories that we're going to be looking at. The first is the right of a co-owner to alienate, that is, sell or transfer their particular share in the property to somebody else, to a third party, or indeed to another co-owner. Then we're going to talk about the right to occupy the property, that is, to possession of a property which is owned by two or more people. We'll talk about outgoings, so things that might be incurred for the use of the property, for example, rates, water rates, electricity, if it's a commercial building, or other bills for the upkeep of the property. You can think of lots of different outgoings, basically, expenses that the co-owners have. Improvements to the property, to what extent do co-owners have a right to make improvements to the property, and whether, more particularly, can they claim reimbursement from another co-owner for any work they've done to the place. And then finally we'll talk about this concept of an occupation rent or an occupation fee, and in what circumstances one co-owner might have to pay this to another co-owner based on principles mainly of equity. So firstly, there's that basic understanding that a co-owner, whether they're a joint tenant or a tenant in common, has the right to alienate, that is, sell or transfer their share to somebody else. We'll talk about what happens to the co-ownership when that actually occurs, but you should be aware that it is the individual's right to deal with that particular share of their interest in the property in any way they see fit. That may or may not bring an end to the co-ownership arrangement. We'll talk about termination of co-ownership in the next podcast. Just bear in mind that that doesn't mean that they can then sell the entire property. To do that, they would need the signatures, i.e. the consent of the other co-owners. But their particular share, they have a right to alienate. Now, in terms of occupation, the general rule is that each co-owner is entitled to occupy the entirety of the premises. That is, they're not, as I said in a previous podcast, not restricted to, well, you own a third of the property, so therefore you can have the back room, I'll have the second bedroom, and the other person can have the third bedroom. It doesn't operate like that. You can consider it as them being co-owning the entirety of the property and having a right to occupy the entirety of the property. From that flows these concepts that one party can actually invite a stranger onto the property. They might, for example, create a lease over one item of the property, that is, carve out a lesser interest in the estate. And there are, if the property was owned by joint tenants, there is some indication that might actually sever the joint tenancy, but we'll talk about that in a future podcast. But for now, all you need to know is that they have a general right to invite a stranger onto the property. And finally, this concept that I put a couple of cases down the bottom there, which I refer you to have a look at, or at least the commentary of in the textbook, that if one party ousts another, that is, formally says, I don't want you in here, then that party may be liable to pay a form of occupation rent and possibly damages to the other co-owner. And this flows from the fact that all co-owners have that entitlement to occupy the entirety of the premises. We'll talk about ouster, the doctrine of ouster and occupation rent later in this podcast. So when I said I was going to talk about ouster later, I meant now. So ouster is basically the wrongful prevention of another from using the property. So one co-owner makes an explicit um, intention in writing or in their actions to prevent another from coming back into the property. So you not actually force them out of the property. You might do a bunch of things, not necessarily just changing the locks, but writing them saying that you've got no more interest in this property, I never want you around here anymore, I'm going to take a court order against you, I'm going to change the locks. So you might do several things which give the indication that you, as a co-owner, have excluded or prevented the other co-owner from actually using the property. Now, there's a little bit more of a discussion about ouster in paragraph 8.260 of your text. Outgoings. So basically, these fall into two categories. Some are joint debts, which are incurred by the co-owners. For example, water and council rates are generally considered to be jointly owed by those co-owners, and therefore each is responsible for their respective share. So the example, if a co-ownership situation was tenants in common 50-50, then they would be responsible for 50% each. If on the other hand it was 2/3, 1/3, it may be that the court says, okay, it's 2/3 your responsibility and 1/3 yours. On the other hand, there's another category of things like insurance premiums, pest control, and other types of fees, which are generally, there is no obligation, no common obligation to pay for those jointly. The question is really whether you can find that there's been a joint obligation in the co-ownership to make payment for those types of things. So for example, if there's an obligation under a mortgage that they need to insure the property and the mortgage is jointly held, then those insurance premiums could well be a joint debt. So there's some cases there that I put for you, which are also in your textbook, Lee and Dickerson and Forgiard and Shanahan. So for improvements, it's a bit trickier than just saying no. A common law would say there'd be no compensation at all for any improvements that one co-owner did to the property, unless there was some form of agreement, of course, between the co-owners. However, in equity, the courts have said that if one person goes to the extent of doing some improvements, and those improvements enhance the value of the property, then at the time of the co-ownership coming to an end, that person can make a claim that an adjustment should be made in their favour. This is an interesting principle. It happens at the end of the co-ownership arrangement, so not during. At the same time, there's generally no requirement to pay for or to claim compensation absent an agreement for cost of repairs. Even though those repairs might be entirely necessary in the circumstances. So this is a bit of a tricky area of the law. You would assume that kind of be fair that if a person was repairing or improving the property, that they might get some compensation for that. However, if the other co-owner hasn't agreed to it, then we're looking at the fairness for them and balancing it up, saying it's not fair that they actually contribute to it. If, for example, they thought, well, we didn't need to improve the property. Anyway, all you really need to know is that compensation may be payable in equity. You can cite this case of Brickwood and Young, and there's a bit more of a discussion at 8.240 of your textbook. Right, this concept of occupation rent. This is a thing which is payable, of fee basically, which is payable and may be payable from one co-owner to another, where that other co-owner is not in possession of the property anymore. So you, for example, might think about the case we had a few slides ago where I was talking about the concept of ouster. So that becomes relevant here. So if the co-owner has been ousted from the property, then essentially the court will say, well, that person has their rights have been infringed. Their rights to possess the entirety of the property, like the other co-owner, have been infringed, and therefore some form of nominal fee or rent should be payable to them. So that's the case of Pascoe and Swan, and you can see that that's the second dot point there. The first dot point is the previous slide we're talking about, in circumstances where a person has made improvements to a property and then turns around and says, I would like compensation. Brickwood and Young says, well, they can only really do that at the end of the co-ownership arrangement. But to be fair, i.e., which is what equity is looking at, to be fair to both parties, if that person has been in sole occupation while they've been doing the improvements, they need to pay an occupation rent to the other person. So in such a case, it'll be offset between what's happening, how much they're seeking to claim for the improvements and how much they have to pay for the occupation rent. So it might not, for example, be worth that person's time who did the improvements to actually claim for them, because they might have to pay even more money in occupation rent to the other co-owner. Finally, there's a third situation which is kind of interesting, and that is a situation where a New South Wales court found in the case of Kello and Lupchev that a relationship might have broken down between the co-owners, and in such a case, the court says, well, this is not really an ouster, but it might be a separate independent ground on which the court can compensate an owner for the exclusive use of the property by another owner. For example, through that compensation, it might be through the form of occupation rent. So that's a separate category altogether that you need to keep in the back of your mind, so that if there's some sort of breakdown in relationship between the co-owners, and that it just wouldn't be feasible for that co-owner to live at the property, then potentially the court might say, well, okay, exclusive use by the other owner, the other co-owner, needs to be offset by them having to pay some form of rent or compensation to the one who did not live in the premises. So here's a basic statement from that Kello and Lupchev case. The basic principle that a tenant in common is not liable to pay an occupation rent by virtue merely of his being in sole occupation of the property does not apply in the case where a matrimonial or similar relationship has broken down and one party is, for practical purposes, excluded from the family home. So this is a narrow set of, well, not narrow set of circumstances, but a set of circumstances that will apply, provided that evidence can show that the relationship has broken down to such a point that person no longer, it wouldn't be reasonable to assume that they could go back in and live in the property. Is it ouster? Well, it's not really. It's actually a separate category on its own for when occupation rent might be payable. You can see the court in Kello and Lupchev says one can describe the breakdown of a domestic relationship at ouster, but it actually is better to recognise it as an independent ground for charging the co-owner who remains an occupation rent. So you might just conceptualise it as not an ouster as such. An ouster is more of the formal rejection of a person's rights to actually enter the property. There's a note there in your textbook about the discussion of the amount that could be paid for occupation rent. Basically a fair market rent for the premises. So you might look at a couple of premises nearby and say, what are they being rented at? What would be fair? And then it has to reflect, of course, the person's proportionate interest in the property. So if the place was being rented for $420, 2 streets over, and they said, well, that's about reasonable for this place, but you had 2 co-owners, and each of them were tenants in common, a 50% share, then you'd say, well, half of 420 is $210, and therefore one co-owner needs to pay that amount, $210 to the other co-owner for the period of time that they were out of the exclusive use of the property. There is a separate section in the Property Law Act that allows for a co-owner to bring an action, and basically to say to the other co-owner, you owe me a share of the rent in this premises, and that's a action to account, basically. The co-owner shall, in respect of share of income, for example, through rent, which is more than just and proportionate, must be liable to account to the other co-owner of the property. So that's basically it in this podcast. We were talking just then about what happens when there are disputes between co-owners, and they largely arise from occupation of the premises, things like joint debts, whether one co-owner can invite another person onto the premises, things you would need to think about in a factual scenario. Well, what are the circumstances in which this person is no longer living in the property? For example, have they left on their own accord? If they have, then there's unlikely to be some form of ouster if they just decide to pick up and leave and go overseas. On the other hand, if the person said to them very specifically, I don't want to ever see you again in this house, I'm going to take out a court order against you, I'm going to change the locks, and I'm going to do a whole bunch of other things which make it very difficult for you to come into this property, then that is likely to be an ouster, and therefore an occupation rent might need to be paid to that other person. The other thing we were talking about was improvements. So if one co-owner did some improvements to a property, to what extent would they claim compensation? Well, the general rule is that common law, there is no rights to claim for repairs or compensation. But in certain circumstances at the end of a co-ownership, equity might provide for some form of compensation to be paid. However, that might be offset by an occupation fee if another co-owner has not been in possession of the premises during that period. Right, so that's it. In the next podcast, we'll talk about the termination of co-ownership. But for now, you just need to know about those key cases that I've set out in the podcast. Section 43, the liability of the co-owner to account, and how the factual circumstances might change the outcome of a dispute between co-owners in those types of circumstances.